Good morning, everybody. Thank you for joining us for today's webinar. My name is Amber Hines, and I'm the owner of Ashbur. We specialize in Medicaid compliant annuities, and today I'm super excited to have attorney Mark Munson co-presenting with me on Medicaid planning for individuals that do not have a spouse. Mark, did you want to say hello?
Good morning, everyone. Glad you could join us. Looking forward to this time with you.
Perfect. So Mark is a certified elder law attorney. He practices primarily in the state of Wisconsin, which is where I'm from. We were actually just talking about all the snow and gloomy weather in Wisconsin. I no longer live there. Like I said, my name is Amber Hines, and I'm the owner of Ashbur. If you have any questions during today's webinar, feel free to type those into the questions bar of the GoToWebinar dashboard. And then also, if you're interested in the handouts from today's session, you can also download those in the GoToWebinar dashboard as well. I'll start out by telling you a little bit about myself. Again, my name is Amber Hines. My maiden name is Gwynn, which some of you may know me by. I've spent the last 15 years working with elder law and estate planning attorneys on Medicaid compliant annuities. I am insurance licensed in all states and hold a Series 65 license with FINRA as well. And I created my insurance agency, Ashbur, to assist advisors and attorneys with pre-planning solutions such as hybrid long-term care insurance, as well as crisis planning with Medicaid compliant annuities. We can help you in a variety of different ways as far as we offer complimentary case analysis. So we will help you to determine the optimal amount that an annuity can be purchased for, the term of the annuity, and which assets your clients may consider annuitizing. This sometimes comes into play if you have clients that have existing IRAs or non-qualified annuities that we are potentially needing to spend down for Medicaid qualification. We can look at doing a 1035 exchange or an IRA transfer of those types of assets. So we can help to determine which assets it may make sense to annuitize and use to privately pay for the client's care. We offer assistance from the beginning to the end of a case. We will provide quotes for you to discuss with your clients. We offer assistance with the actual funding of the Medicaid compliant annuity by way of either a trustee to trustee transfer, wire transfers, or the client issuing checks to purchase the annuities. And then we also offer assistance if we have a situation where a client purchases an annuity from us and they pass away during the term of the annuity contract. If the state is listed on the annuity as a primary beneficiary, we would take care of reaching out to the state Medicaid agency and obtaining either a clearance letter from them or documentation as to how much the state has paid on behalf of the client so that the secondary or contingent beneficiaries can receive the remaining annuity amount. We do work with A-rated insurance carriers, and we offer top-notch customer service as far as getting back to the clients that we work with within a 24-hour period. When we have an individual client that does not have a spouse and they are currently in a nursing home applying for Medicaid, we do not have a well spouse or a community spouse that we're able to transfer the majority of the client's assets to, and we don't have the spousal impoverishment protections to allow the community spouse to keep $148,000 because we're dealing with just a single individual. So we're very limited as far as the type of planning that we can do for an individual client because an individual is only able to keep a very limited amount of assets in their name and still qualify for Medicaid, which is what we're going to be talking primarily about today. So when we have an individual client that does not have a spouse, we of course will have income and asset limitations for an individual. When we have an individual client, their income must be less than their cost of care in most states, unless we are working in an income cap state. If you're in an income cap state, then their income must be no more than $2,742 per month. If their income is greater than that amount, then we must establish a qualified income trust or a Miller trust in order for the client's excess income to flow through that trust and meet the income limitation for Medicaid qualification. If we have an individual client that does not have a spouse, their assets are typically going to be capped at no more than $2,000 of liquid assets that they would be able to keep in their name. This is going to include assets like checking, savings, brokerage accounts, cash value of a life insurance policy, existing annuities that the clients own that have cash value. This number does vary from state to state, but the most common number is a $2,000 asset limitation. There are some other resources that are going to be considered exempt or non-countable when qualifying for Medicaid. Some of the assets that you're seeing on the screen, such as the client's home, an automobile, household goods and personal property, an irrevocable funeral trust, or a prepaid burial. And then some states do consider an IRA to be a non-countable asset as well. This does depend on the state, but in most situations, the IRA will be considered countable if we have just an individual client that is applying for Medicaid. Mark, did you want to add anything else on this slide as far as the type of assets that are protected, or anything else on this slide?
Not much, Amber, other than just to say what's on this slide is exempt property, exempt from Medicaid eligibility, and it's probably the first thing that in any case where you're looking at Medicaid eligibility, usually the first thing that you want to do is identify exempt assets. And while we have on the slide here the home being an exempt asset, it is an exempt asset for purposes of Medicaid eligibility, as long as there's an intent to return home. And that intent doesn't need to be real or realistic. It just needs to be conveyed. Hey, I intend to return home. As long as that intent to return home is conveyed, the home is an exempt asset from the standpoint it doesn't count towards the $2,000 asset limit or whatever the asset limit is in your state. But it's important to note that the Medicaid program in your state can put a lien on a client's home. So while it is exempt for purposes of Medicaid eligibility, that doesn't mean it's in quotes protected. And so it is subject, it is an asset. In fact, it's the only asset of real property that can be subject to a Medicaid lien. And if your client owns it at the time of his or her death and was a Medicaid recipient, then it's going to also be subject to estate recovery.
Okay, perfect. What do we do if we do have a client that has excess assets over the $2,000 asset limitation or the asset limitation in your state? Usually we're going to develop a Medicaid eligibility plan, which can include increasing or improving non-countable assets, like making improvements to the home, purchasing a new car, things of that nature that would improve or increase the non-countable assets that a client owns. Also, we can look to purchase prepaid burial policies that would not be considered a countable asset for Medicaid qualification. And then also look to pay off any mortgages, credit card debt, or other debt that the client has. And then finally, if there are other assets that are remaining after all of these items are considered, we can consider purchasing a Medicaid compliant annuity that would comply with the Deficit Reduction Act of 2005. When we're looking at annuities that do qualify as a Medicaid compliant contract, there's a lot of different insurance companies out there that offer annuities, but there's less than 10 companies that offer a Medicaid compliant contract. A Medicaid annuity must always be a single premium immediate annuity, meaning that it's in payout status. It is strictly an income stream. It can never be a deferred annuity, because a deferred annuity would be considered an asset for Medicaid eligibility purposes, because there is cash value associated to a deferred annuity. A single premium immediate annuity is an annuity that is issued by an insurance company that's used to convert a lump sum of assets into an income stream. And once that policy has been annuitized by the insurance company, there is no longer any cash value that can be accessed by the client. It would only be the income that they are entitled to on a monthly or on an annual basis if they choose to receive yearly payments instead of monthly. As a result of the Deficit Reduction Act of 2005, immediate annuities must meet very strict requirements, which we're going to go through. The requirements that an immediate annuity must have within the contract in order to comply with the Deficit Reduction Act are on your screen. The first requirement is that the annuity must be completely irrevocable, meaning that we can't change any aspect of the annuity policy after it's issued. We wouldn't be able to change the payment amount, the parties on the annuity contract, such as the beneficiaries or the payee. Also, the annuity must be non-assignable, meaning that we can't assign the annuity to a company like J.G. Wentworth or Peachtree, so that it would not have any value on the secondary annuity market. It also must make equal payments without any balloon payments at the end. This would only be a requirement of a Medicaid compliant annuity that is purchased with after-tax dollars. There are some exceptions to annuities that are purchased with IRA dollars, but in general, the annuity cannot have a balloon payment at the end of the annuity contract. Also, the policy needs to be actuarially sound, meaning that the client will receive the full amount of the annuity within their Medicaid life expectancy. It can be structured for a shorter period of time and still meet the actuarially sound requirement, but we cannot structure the annuity so that is longer than their Medicaid life expectancy. And then finally, the final requirement is that the state Medicaid agency must be listed as a remainder beneficiary on the annuity policy, to the extent that they would be providing Medicaid benefits on behalf of the Medicaid applicant. We do have an asterisk there because there are some exceptions to this. If we have a minor or disabled child, they can be listed as a primary beneficiary before the state Medicaid agency. But in general, in most cases, the state does need to be listed as a remainder beneficiary. The different planning opportunities that involve a Medicaid compliant annuity: when we have a single applicant that does not have a spouse and we're trying to obtain Medicaid eligibility as quickly as possible, there's really two different annuity options. We can first consider a gift and annuity plan, which is, I would say, the most popular planning strategy that we use when we have just a single applicant that is applying for Medicaid. The second strategy that we can try and use is using a standalone Medicaid compliant annuity. This would involve not making a gift, but strictly spending the client down by purchasing an annuity that is structured over their Medicaid life expectancy. We don't use that second strategy as often unless we have a person that has a very limited life expectancy. So today we're primarily going to be discussing the gift and annuity planning and what the calculations and the economic results look like when we have a single person that wants to do a gift and annuity plan. We're going to look at a case study with Mary, who is 80 years of age, and after living at home with dementia for years, she's now in need of nursing home care. Mary's family feels that she could live for another 5 years in this sort of supportive care environment. She has around $205,000 of after-tax dollars, so money that's sitting in just checking or savings. We're not dealing with any kind of non-cash assets in this case. And then she has monthly income of $2,000 from Social Security and pension. And then she's currently paying around $10,000 per month for her nursing home cost. We arrived at the $205,000 spend down amount by taking Mary's total assets of $230,000. We suggested that she purchase a prepaid funeral policy for around $10,000. She also paid legal fees of $12,000 in this case. She needed some personal items, new clothing, and things of that nature, which she spent $1,500 on. And then also we suggested that she keep around $1,500 in her checking account. We like to leave around a $500 or $200 buffer there. Although she's able to keep $2,000 of assets in her name, we spent her down to $1,500 just to make sure that we had a little bit of cushion, which means that she has a remaining spend down amount of $205,000 that we're really looking to do the gift and annuity plan with. Mark, did you want to add anything about the different spend down items here, or legal fees or things like that?
No, not particularly. I hope that our attendees are not caught off guard with the legal fee amount, because you know what you're providing in doing a case like this is a lot of value and a lot of service and a lot of assistance, and to be able to take Mary and her family through this process, through the whole process, which includes the Medicaid application itself, and you know, seeing to it that that application gets approved. You can't guarantee that as an outcome, but you can use your knowledge of the law in this area and your advocacy to make sure that that application is handled and processed correctly, so that the result that you're trying to obtain for your client is what is the way your state sees it after they process the application as well. So there's a lot that goes into this type of planning and this type of representation. So just make sure you take everything into an account when you are thinking about your legal fee in a case like this.
Okay, and would your fee vary based on if the client has existing like real estate, if there's other assets that are going to be more complicated to do this type of planning with?
Yeah, so in our office, we do this kind of work on a fixed fee basis, and I've been doing this for long enough period of time that I guess I'm comfortable doing that. But you know, I kind of base my fixed fee on two things. One is that the time that I'm going to spend, and that is it's going to be more if there are illiquid assets as opposed to just cash. It's just, that's my time and my I guess my brain has to be used a little bit more than if it's just cash. Today we're just going to go through this, you know, this session is a little bit easier in the sense of having cash only. But if there isn't cash only, which is a lot of times what you're going to run into, you're going to have additional time and additional considerations of what do we do with these illiquid non-cash assets. And then the second thing is, besides time that I use to develop a fixed fee, is the value derived from having me involved. And yeah, I hate to say it, the bigger the case, the more value I should be able to deliver, and I factor that in. But I think one of the things that's important for you to do at the onset of the representation is to be able to share with the client and her family, in this case, the value of what you're going to be able to provide by being involved. And so, if you look at, I'm setting the stage that we could move on to some of these slides, but if you're setting the stage here, Mary's got a $205,000 problem. She's not going to be eligible for Medicaid until we make $205,000 disappear or do something with it. And so that's not a trivial number. That's a good number. And if you want to make sure that you get paid fairly for your time and for your expertise to help a client and her family in a case like this.
Okay, perfect. Thank you. If we go back to the calculations of how we're going to calculate the gift and annuity amount, first I'm going to consider how much monthly income Mary needs to bridge the gap or the shortfall between her cost of care and her income. So if you recall from the summary slide talking about the cost of care and her income, she was spending around $10,000 per month on her nursing home costs, and she has $2,000 a month of income. So she's short $8,000 a month from being able to cover her nursing home cost. If she were to do nothing at all with the $205,000 and just continue to privately pay for her care, she's going to exhaust all of her assets within a 25-month period, so just over a 2-year time frame. And with Mary's family anticipating her to live for many more years, doing nothing or no planning at all is not going to be a great option, because after the $205,000 is exhausted, she's going to need to go on Medicaid anyways. And so we're looking at the best planning options that we would have available to Mary based on her anticipated longevity and the fact that she has $205,000 that is remaining that needs to be spent down. With the first option that we're going to be talking about, we can structure a gift and annuity plan. And with the gift and annuity plan, we're allowing a single Medicaid applicant that does not have a spouse to make an immediate wealth transfer of a portion of their assets to their intended beneficiaries or into an irrevocable trust in order to trigger a penalty period or a private pay period for making that gift. It would allow for the single applicant to qualify for Medicaid at the end of the private pay or ineligibility period that's associated to making a gift. I like to think about the client's assets, the $205,000 that we have remaining that needs to be spent down, as the money going into 3 separate buckets when we're doing a gift and annuity strategy. So as a result of the Deficit Reduction Act of 2005, in order for the penalty period or the private pay period to start, the single Medicaid applicant must be asset and income eligible, meaning that their income must be less than their cost of care and their assets must be less than the $2,000 asset limitation. And so if we think of the 205,000 going into one of the three buckets on the screen, they're either going to keep money in the $2,000 asset limitation bucket that they're able to keep, or they're going to put a portion of the money is into a gift, and then the remaining amount is going to be used to purchase a Medicaid compliant annuity to convert the asset into an income stream so that we can provide almost enough income to pay during the private pay period. The first step
Can I
is,
just add one thing, Amber, there?
yes.
That's all right. If you want to hop back to that slide, with the DRA, the terminology is otherwise eligible, and in order to start a penalty period, because of a gift that's been made within the 5-year look back period, the applicant needs to be otherwise eligible. And there are really, four criteria that need to be considered to be otherwise eligible. The first two are non-financial criteria. One is the applicant needs to be a US citizen. So usually for all of us, not a problem. Just that's not going to be a problem. The second is that the applicant needs to be elderly, blind, or disabled. Elderly is defined as 65 years of age or older. So that's the definition of elderly. So those two things are the non-financial requirements to be eligible for long-term care Medicaid. Then, as Amber has mentioned in this slide, there are two financial requirements to be eligible for long-term care Medicaid. One is income. Your income has to be less than the cost of care. Well, Mary qualifies for that. She's in a care home. It's what do we say? It was 10 a month, Amber?
Yes.
Or 8 a month?
10,000.
Doesn't matter, but it's 10,000 a month and her income is only 2. So Mary passes the income test. So Mary's a US citizen. She's elderly because she's over age 65, and she meets the income test. Mary's problem in our example is she's $205,000 over assets, because the fourth test to be otherwise eligible for Medicaid is your assets have to be $2,000 or less, or whatever limitation your state has. So Mary's problem, if you will, with respect to Medicaid eligibility in this case is not her citizenship, it's not her age, and it's not her income, it's her assets.
Yes, okay. Thank you, Mark. So first, we're going to determine the monthly income shortfall, which we already have done. We're first going to compare the cost of care at $10,000 and subtract out monthly income at $2,000. So we see that the shortfall on a monthly basis is $8,000 per month. Then we're going to determine the burn rate, or the amount that we can gift and use to purchase the annuity. We're going to do this by adding the income shortfall of $8,000 per month to the divestment penalty divisor. In this case, we're using Wisconsin numbers where Mark practices, and the monthly amount, I'm just going to say, is $93.89 on a monthly basis. We add those two numbers together to determine the burn rate at $17,389 per month. The divisor is going to be a number that each state publishes, and it is supposed to represent the average cost of 1 month in a nursing home in your state. This number does vary from state to state. States that are in the southern part of the country by me are going to have a lot lower divisor amount than a state that is in the northeast area of the country. Those numbers are usually anywhere between 12,000 and 15,000 per month for a divisor. So the number that we're using in Wisconsin is a pretty average amount if we're looking at the country as a whole. Medicaid is going to calculate.
Sorry, Amber.
Go ahead.
Just worth noting that this divisor, which again represents the average private pay nursing home amount in your state, this number changes every year. So something just to be mindful of with respect to your state.
Yes, thank you, Mark. When we next determine the penalty period, we're going to take the spend down amount of 205,000 and divide that by the burn rate of $17,389, and we determined that the term of this plan is going to be 11.78 months. We adjust that the plan term from 11.78 months up to a 12-month time frame, and we multiply that 12-month time frame by the divisor of 93.89 to determine the gift amount of 112,679. This is the amount that Mary is going to gift to children or to a trust or gift out of her name in order to start the private pay period associated to making this almost $113,000 gift. The annuity amount now needs to be determined from taking the spend down amount of 205,000 and subtracting out the amount that is gifted at 112,679, and we determined that the annuity amount is going to be $92,320. We're going to place this into a 12-month annuity that is going to make a monthly payment of $7,710 per month. The total payout is $92,520, and that was just determined by taking the 12-month time frame multiplying by the monthly payment of $7,710. You'll see that the total payout is just slightly more than the amount going into the annuity. This is the small amount of interest that the insurance company is going to pay back to the client when they also return the principal amount of the $92,320. You'll notice that the annuity can only be structured for a whole number of months, which is why we did a 12-month time frame instead of the 11.78 months. The annuity would have to either be structured for 11 months or 12 months. We cannot do a fractional time frame of the annuity in order for it to work for Medicaid and be considered actuarially sound. During the private pay period, we're going to add Mary's income that she had of $2,000 from pension and Social Security to the annuity income at $7,710, and we determined that the total income that Mary has during this 12-month annuity time frame is $9,710 per month. We're now going to determine the income shortfall that she has during the 12-month time frame. If we take her cost of care at $10,000 per month and subtract out the $9,710 of monthly income that she has from all sources, then she has a monthly income shortfall of $290 each month.
Which means that Mary's monthly income is still less than her cost of care.
Yes, exactly. So we're intentionally creating a monthly income shortfall in order to meet the otherwise eligible for Medicaid criteria. And so many people ask us why we can't create exactly that $10,000 a month amount in order to, so that Mary could completely cover her cost of care. And it is an intentional shortfall that we work into the numbers so that we are making sure that her total income is below her cost of care of the $10,000 per month. The economic results of doing the gift and annuity plan for Mary is that Mary is ineligible for Medicaid for 12 months. This is the private pay or penalty period associated with making the $112,000 gift. During that 12-month time frame, Mary is going to have total monthly income of $97.10, and she has a monthly income shortfall, like we talked about, of $290 per month. She can use her $1,500 resource allowance that she kept in her checking account to cover that shortfall. And if that is not sufficient to cover the shortfall over the course of the plan, then some of the gifted funds could be used to cover that additional shortfall if there's not enough money in her checking account at $1,500 during that penalty period. Mary would become eligible for Medicaid in month 13 after the 12-month private pay period is over with. As a result of implementing this plan, the advantages are obviously that Mary is able to gift around $113,000 to her children. This is more than 50% of the assets of $205,000. And because the gift of $113,000 was made with after-tax dollars, we really weren't concerned about any tax consequences of making the gift or having to liquidate assets in order to initiate this type of planning. Mary would then receive Medicaid in month 13 after the private pay period is over. The potential disadvantages of this type of planning is obviously if Mary has a very limited life expectancy and we don't anticipate her living through the 12-month private pay period, she would not have actually experienced any economic benefit from Medicaid until month 13 when Medicaid would start paying. So in a case like that, it may make more sense if we do not anticipate them living through the penalty period to simply privately pay and not do the gift and annuity strategy if we don't anticipate them living through that time frame. If we assume that Mary passes away 6 months after the annuity is purchased, you'll recall that the state Medicaid agency was the primary beneficiary. Excuse me. Sorry about that. Bart, did you want to take this slide for me?
Sure. So if Mary passes away 6 months after the Medicaid compliant annuity is purchased, it could very well be that the state that you live in is named as the primary beneficiary, but they're only entitled to get paid if they actually paid something out for Mary. Well, in this case, if she died 6 months after the Medicaid compliant annuity was purchased, your state hasn't paid anything out to Mary because they weren't going to pay anything out to Mary until 13 months. Well, the 13 month, 12 months have to go by because we have a 12-month penalty period. And in effect, what your state is saying is that they would process the application, and in processing the Medicaid application, they would say to Mary, "Hey, Mary, congratulations, you are financially eligible for Medicaid in our state, but because you gave away nearly $113,000, we're not going to start benefits for you until month 13. So for the next 12 months, you're on your own. We're not paying anything." So if Mary passes away after only 6 months into this, unexpectedly, because everyone thought she would live much, much longer, the state's not going to get anything here because the state hasn't paid out anything. So that's an important thing to remember in the context of a single person, Medicaid crisis and eligibility case. It's not a big deal, in my view, to be naming the state as the beneficiary, because if the state actually pays out benefits, the Medicaid compliant annuity will likely be over. If you do the gift and annuity plan, or if the client happens to pass away during the term of the annuity, the state isn't owed anything on recovery because they've never paid anything out yet.
Okay, perfect. Thank you. Now, if we assume that Mary passes away 13 months after the annuity is purchased, with the annuity being structured for a 12-month time frame and the annuity being done paying after 12 months, Mary passing away in the 13th month or later would not have any impact on the annuity contract. And in that case, we won't even need to notify the insurance company that she has passed because the annuity is done paying out in the 12-month time frame. If we look at the time frame for implementing a gift and annuity strategy, usually a gift is made, the annuity is purchased, and we apply for Medicaid all in the same month in order to establish that the Medicaid applicant is otherwise eligible for Medicaid. We then obtain the penalty period determination from Medicaid, like Mark talked about. We use the annuity payments during the private pay period to privately pay during the penalty period. And then after that has expired, then the Medicaid applicant would be Medicaid eligible. And now I'm going to switch screens here, Mark, so that you can talk a little bit about the calculator that you would use for calculating the numbers that we just went through.
Sounds good. So Amber's going to put up a spreadsheet that we've kind of developed in our office for cases like this. So Amber, if you want to, you can. If you want to, anywhere there's yellow, we could just get rid of that and we'll just plug it in so people can see how the calculator works. So, all right. So, the design with this calculator is wherever there's yellow, we want to input something. So in this case, we know that the client's Mary's monthly income is $2,000. So if we put that in, the spreadsheet automatically generates what her daily income is going to be. And then, we also, at least in Wisconsin, we need to do this on a daily. We have to figure things out on a daily level. So from Mary's example, we had a $10,000 rate. So we could put that in. It's close to being $328.77. So the monthly shortfall is, well, let's do the daily shortfall. The daily deficit is, she has to pay out she has to pay out $328.77 a day, and her daily income is only $65.75 a day. So the difference there is a shortfall or a daily deficit of $263.02. Then, because I'm going to joke about this, but I classify myself as the world's most conservative practitioner. What I do, if you look at A12, it says, what's the monthly care rate at 27 days? And this, because February is a short month. And what I'm getting at is I want Mary's income during the penalty period to be under what it would be in what her care rate would be for February. So that's the 9,205.56. So then the amount of monthly income needed, what that is telling me in someone like Amber is it's saying, okay, we want an annuity payment of around 7,524. That's about what we're looking at, because if we have that coming in, we know that Mary's monthly income is always going to be less than her cost of care, even in the month of February. Even in the month of February, her monthly income is going to be less than her cost of care. So then we have the Wisconsin penalty divisor in there that's expressed as a daily figure rather than a monthly one. And then, you know, again, if you look at A18, what is that? That's that burn rate number that Amber talked about earlier. It's not a monthly burn rate, but it's a daily burn rate. That's what I've got here in this calculator. So current assets, I think we said 230, and she's going to spend down 12,000 on attorney's fees and 13,000 elsewhere. And that takes us down to 205. And if we, you know, again, this is the program, the spreadsheet just spits out all this number. So, you know, going back to our example, if you look at A29, the monthly penalty period, 11.79 months, which is exactly where Amber was when she was going through the slides with you. So, you know, if we round that up, you know, we either got to round down to 11 months or we have to round up to 12 months or maybe 13 months. But we have to get a round number for the annuity. That's Amber's the expert in that, and that's what she said. I can't do a 11.5 month annuity. It either has to be 11 months or 12 months. So then we're going to round up and put in 12, and Amber put in 12. And essentially, this is going to give you a very, very close number to what we need for that Medicaid compliant annuity. And it's going to give you what you need for the gift. And then the red shows you what your penalty period is going to be. In Wisconsin, we do it on a daily basis, not a monthly basis. So the penalty period here would be 371 days. We drop the decimals, so the very technical penalty period amount is 371. Which is about 12.22 months. So what's probably going to need to happen is some of the gifted funds, the 114, we're probably going to need to get that back to Mary somehow, some way during this penalty period or private pay period. And so what this is showing, the true value of the gift may be around 109,000, but that's pretty valuable when you start with 205. So with 205, you are looking at protecting for Mary's children and having available outside of the Medicaid system $109,000, which is nothing to sneeze at in a case like this.
Thank you, Mark. Did you want to talk a little bit about how you go into meetings with families when you have just a single individual?
Sure. So what we're talking about this time is it's very, very easy because it was just cash. I think next time Amber and I are looking to talk about this exact type of planning scenario when it's not as easy. But anytime you are faced with these facts, What are the facts? A single person, widow, widower, never married, divorced, whatever it is, you are dealing with a single person who's in crisis. Now, what do I mean by crisis? Financial crisis. Most families in America, not the Bill Gates of America, but for most families, $10,000 a month to the nursing home is a financial crisis, and they need to do something about it to solve that problem. And so when that case is presented to you, as a general rule, with what we've gone over today, I always approach those cases with half. I'm going to save, without knowing any of the facts, I just go into that meeting thinking we're going to be able to do some gift and annuity planning as long as the client and the client's family is up for that, but we're going to be able to save half. And it is helpful. What I do when meeting with clients, when the facts are this, I try to do those calculations, very, very roughly. We're not getting it down to the penny just yet, but you try to run those calculations so that you can convey to the client and the client's family members the value for having you involved. And so in a case like this, I would want to calculate the numbers on a very, very, roughed out basis. And I would be saying to the client that, look, if you do nothing, if your mother does nothing, she's going to be out of money in 25 months. And that's if she does nothing. If we do some Medicaid planning, moving some money around and, do these things that are all legal, by the way, everything is there's nothing illegal or not permitted by what we're doing. But if we do this planning and we move some assets around and we purchase this annuity, we're going to be able to save the family or get to the family around $110,000. And, I think the economics of that, especially if Mary has a longer life expectancy, Mary, if she's of sound mind, is going to like the fact that some of her money can get to her kids. If she's not of sound mind, a key here is making sure that there hopefully is in place a very, very good power of attorney that allows, some of these things to take place. The power of attorney allows for gifting. The power of attorney allows for the purchase of an annuity. If not, that's tougher, because if the agent under the power of attorney isn't authorized to do things, they're not authorized to do things. So, it's important to take a look at the power of attorney if Mary is not of sound mind. I mean, it could be that she's needing long-term care because of getting to the point of having severe Alzheimer's or dementia and can't sign anything at this point. So, sometimes people have to go to the nursing home because of physical issues. They can't move around, they can't eat, they can't trust themselves. But their mind is just fine. In that case, maybe you want to look at getting a new financial power of attorney put in place so that if the mind does get to the point of no longer being of sound mind, that the power of attorney is going to allow you to continue to do planning and do things for this individual. So, but getting back to the financial side of it, if it's a single person crisis case, meaning they're in a care home and their care costs are not covered by Medicare or any other insurance, so they have uninsured care costs, and they have a larger monthly deficit or larger monthly shortfall, that's going to be viewed as a crisis for them. And how can we solve that crisis as soon as possible? That's where they're going to come to you and ask for you to work your legal magic so that we could protect some of the money if that's what they want to do.
And Mark, do you find that most families are satisfied when you tell them that you'll be able to protect around half of the assets?
Yeah, I think, Amber, I'm going to go to what something you mentioned earlier, if that, and if we take this case of Mary, Mary might have, everyone thinks Mary could live for 5 years, right? So, if Mary does nothing, she's going to need Medicaid in 25 months. If Mary does something, she's just going to get Medicaid 12 months earlier or 13 months earlier. But either way, she's going to need Medicaid. But Mary's probably going to feel better about getting some of her life savings to her children. I mean, I don't meet many parents who will say, no, I don't want to do. Some do, trust me. Some do. And they just say, I want to pay for my way and then I'll go on Medicaid. But most parents would like to see, and actually when you present it to a client that you're using some of your money to pay for your care, but you're also using some of your money to get to family, to help out family. Most of them are pretty receptive to that, and that's what they want to do.
Okay, perfect. So Mark kind of alluded to this, but next month we're going to be doing a part 2 to this webinar, and we're going to be addressing issues that come up when we have clients that have non-liquid assets that we're trying to do a gift and annuity strategy for. If they have real property, if they have money that's in non-qualified annuities, life insurance, things of that nature. So really any assets that are not just sitting in the local bank and checking or savings, we're going to be addressing the challenges that come up with clients that have non-liquid assets that we're trying to do a gift and annuity strategy for. So be sure to join us for the April webinar as well. I did include both of our contact information on this last slide so that if you have questions for Mark, I know that Mark, you usually are traveling around to different NAILA conferences and you're a national speaker at different conferences. So if you have questions for Mark, you can feel free to reach out to him directly. We do have a couple of questions here. Mark, there's a question of what do you do for a single client who is not age 65 before says they were on Medicaid before entering a nursing home, but they're not age 65 at this point.
Not age 65, have they been determined disabled by Social Security?
It sounds like it, yes.
Yeah, so you're looking at doing the same type of planning then. So again, the non-financial criteria is US citizen, and then elderly, 65 or older, blind or disabled. If you're blind or disabled, it doesn't matter, and that has to be as determined by the Social Security Administration, not by your doctor, not by a long-term care insurance. It has to be by the Social Security Administration. But if you're blind and disabled as determined by the Social Security Administration, then your age is irrelevant.
Okay, and then we have another question here about, we live in a managed care state. If Medicaid approves the application but pens for the penalty, is a managed care lien still accruing, i.e. Medicaid would be owed something if Mary dies during the term of the annuity contract?
I don't think so, because they shouldn't be paying anything out during a penalty period.
Okay. Perfect. Those were the only questions that we have currently, and I know that we're at time right now. So, like I said, if anybody has any questions, feel free to reach out to myself or to Mark. Both of our contact information is on the screen. I want to thank everybody. Thank you, Mark, for being with us today, and we look forward to talking with all of you in the month of April.
Thanks, Amber, and thanks everyone for attending. We appreciate it.
Thank you.